Okay, I see Ashley Nonis from Credit Acceptance.
I'm here.
Okay, I'll give Buchanan a couple more minutes. Mary Buchanan has not appeared, so we'll wait a couple more minutes, okay?
Okay.
Okay, and then Mr. Cooch, you're here with Stephanie Schmitz.
Yes, Your Honor.
Having a hearing on this matter?
No, Your Honor. It'll be a plea with an explanation.
On the record in the matter of the people of the city of Lansing versus Stephanie Ann Schmitz, file number 21-004330D, council appearance.
Good afternoon, Your Honor. Dustin Coons for Stephanie Schmitz. She is seated to my left in my conference room. We're appearing by Zoom.
And O'Boyle appearing at the city of Lansing.
Were previously arraigned on back on April 25th, 2022. You were advised of your rights at that time. You were advised that you had a right to have a contested hearing as it relates to the allegation that you tested positive for alcohol on February 24th, 2022. The amount of ATG 313 nanograms per milliliter, and that on March 9th, 2022, you also tested positive for alcohol with an ETS of 49,450 nanograms. And so you do have representation today by Mr. Coombs. He's advised the court that you wish to waive your right to have the contested hearing today and enter a guilty plea with an explanation. Is that correct, ma'am?
Yes, Your Honor.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Okay, you can put your hand down. Ms. Schmitz, is anybody making any promises to you to get you to waive your hearing and plead guilty today?
No, Your Honor.
Okay, is anybody threatening you to get you to waive your hearing and plead guilty to the probation violation?
No, Your Honor.
Are you pleading guilty because you believe you're guilty?
Yes, Your Honor, just due to the circumstances.
Okay.
He said that I can.
You said due to the circumstances, he said that you could plead?
Well, I was just gonna say the circumstances was I had.
Well, my question was, are you pleading guilty because you believe you're guilty?
No, not from drinking alcohol. I'm not guilty for that.
Okay, well, we can have a hearing.
Your Honor, this is, I think this is one of those, the defendant wasn't careful about what they're putting into their body type cases. We're not disputing the findings from the lab. We're just, I think what Stephanie's trying to communicate is she wasn't purposefully, she wasn't ripping shots or drinking beer or anything like that. So that's the explanation part of it that we want to give.
You mean on both the 24th and on the 9th? Your explanation is that she accidentally drank alcohol?
Accidentally, purposefully ingested a substance that she didn't know had alcohol in it. Yes.
On 2 separate days?
Yes.
Okay. Can you get the probation officer here? Okay, we're off the record. I'll have the probation officer log in for a hearing. Okay, Mr. Hannah is here. Okay, wonderful. Okay, Mr. Carter, are you representing Mr. Sierrowski?
I am, Your Honor.
Okay. Are we having any hearings?
We are. I could give the court a stipulation of facts, and then the court can decide whether or not that rises to the level of a probation violation if you'd like. That would be the quickest way to go, I think.
Okay, well, since we're potentially having two hearings, I'm gonna handle a civil matter so they can go on about their day. Let's see. Buchanan has not appeared on your matter for review for credit acceptance. Ms. Nana says she's been making payments.
Good afternoon, Your Honor. No, she has not paid in accordance with your order. She didn't pay February, didn't pay March. She only paid $100 in April, and she's got a couple days to make the next payment, but based on her history, I doubt she's gonna make it.
Okay, well, I will grant a motion to set aside installment payment if you want to submit one.
I will do that. Thank you, Your Honor. Have a great day.
Thank you, same to you. Mr. Stevenson is here.
Good morning.
Matter against Venetia Walker. I don't see Ms. Walker though. No one in the hallway. No one's here. On the record in the matter of Venetia Walker versus Christine Oldenburg McGee, file number 21-03330 GC, council appearance.
Michael Stevenson on behalf of the defendant.
Thank you. Today was the date and time set for a hearing on the motion to strike the amended complaint filed by your office, Mr. Stevenson. In response to the amended complaint, the plaintiff has failed to appear. She was supposed to be here by 1:30. It's currently 1:43. We'll grant your motion to strike the amended complaint on the merits. Did you attach a order?
I did not attach a proposed order. I can submit one.
Okay, if you can submit one on the under the 7-day rule.
Will do. Thank you.
Thank you, you're all set.
Thanks.
Your Honor,
Yeah,
when you have a moment, can I please be placed in a breakout room with Ms. Penn?
no problem. I'll do that right now. It looks like you're already in room 3, so I'll add Ms. Penn to your room. Okay. Right. Okay, sounds good. She's in the room with Ms. Penn. But Mr. Roxbury is here on which matter?
Hi, Judge. Oh,
Okay, that's the one that, she's in the waiting room, breakout room. She's here. Okay, Mr. Carter,
Yes,
on the record in the matter of the people of the city of Lansing versus Francis John Zierowski III, file number 20-00035, council appearance.
may it please the court, David B. Carter Jr. on behalf of Mr. Zarowski, who is present through the Zoom app and would waive his personal appearance.
Thank you.
Fando Boyle appearing on behalf of the city of Lansing.
Thank you. Today was the date that was set for a hearing on a probation violation that Mr. Zierowski was arraigned on back on May 16th. Mr. Carter, you said that there was likely to be a hearing, but that you would make a stipulation of facts before we make that determination.
That is correct, Your Honor. And this is what's happened. Mr. Zarowski is on probation in Eaton County, a felony probation. One of his terms and conditions is to complete the MRT program. One of the violations in front of you is that he hasn't completed the MRT program. I've contacted my client and he is still enrolled in that class, so that's continuing. So I guess if there's a time frame in which he was supposed to do it in front of Your Honor, that might be a technical violation, but we leave that up to the court's discretion. But I can assure you that my client is still in that program, and that's something he must complete while he's on Eaton County probation and on a felony case, which he has about 5 months left. The second violation is that he failed to get his GED program. And the stipulated facts here is that he's also ordered to maintain full employment. Mr. Zarowski is employed gainfully, working 60 hours a week, and has finally got into a union in a long-term employment situation, which really has a hard time doing the GED thing. So I think those two terms of his probation kind of conflict with each other. So we leave that to the court's discretion of whether or not he willfully violated. And those would be the stipulated facts of why we're before you.
Okay, the note that I have, at least from the pre-sentence report, which was prepared on September 30th, 2021, was that Mr. Zierowski was already enrolled in or completing the MRT class, and he was continue that for here. So you're saying he has not completed the MRT
But he,
through 30th Circuit?
he is in it. And I'm sorry, if it was 30th Circuit, it should have been 56th Circuit. I believe it's in Eaton County, but he is in that class. He actually has class tonight. It just hasn't been completed.
Okay, yeah, I see. It says he's currently on probation with 30th Circuit, but is supervised for Eaton County.
Okay.
Why hasn't he completed it though?
I think he's muted. Mr. Zarowski, if you could explain to the court why.
I kept asking if I could say something, but I didn't understand. I didn't know that I was muted.
Okay.
So basically that class is 19 to 32 weeks long, being that 31 weeks would be the shortest time that I could get off that class, one. Two, I had caught in COVID about midway through that class and got really sick. And I was out for about 2 to 4 weeks of that class. And so there's another reason why I haven't completed it. The GED, I go to that class, I do that class. I have to go to AA, which I sent him
Okay.
documentation that
I
I was
think that-
doing.
Mr. Zarowski, I think that answers the court's
Okay.
question regarding
Okay.
MRT.
Okay.
Okay, so the violations here that remain on here, I think was failed to attend the moral recognition therapy at Pat's, and then failed to provide proof. So this was that he was failing to attend moral recognition, not that he failed to complete. So he's been attending?
It's my understanding, yes, there's been a little bit of break because of COVID and stuff, but yes, he actually has class tonight.
Okay, and he's providing proof of attendance to probation, because I'm trying to understand why in April they would violate him for not attending. I do have a note here from when he had COVID previously.
Could I explain something, Your Honor?
I think he's been providing his proof of attendance through his other, the Eaton County probation. And it's my understanding, he thought that that's what he was supposed to do.
Okay, Mr. Hannah, can you provide us some information as to why we have a violation for failing to attend the MRT?
Yeah, so at the time of the violation, I hadn't spoke to Francis at all. He hadn't, I think I called his number and it was disconnected. He had changed his number. So I had just put all those violations because I had no proof at the time. I have what I submitted for the supporting documents shows he's been attending the class since 3/28, but before then there was a lot of no-shows, so I kept the violation just because of that. But that was the only thing I ended up keeping other than the proof of obtaining the GED and high school diploma.
Okay, well,
I just thought I thought it should be addressed.
Okay, sounds like he had COVID, so that would explain why he didn't attend.
Okay.
Is that what stipulation was, Mr. Carter?
Correct.
Okay. Okay. Sounds like probation is going to withdraw those remaining violations due to that. Is that correct, Mr. Hannah?
Yeah.
Okay, so then these violations will be withdrawn. You're all set, Mr. Sirlowski.
Thank you,
Thank
Your
you,
Honor.
Your Honor.
Thank you. Have a good one.
Thank you.
Thank you too.
Ms. Corcoran, are you ready to go on the record on your matter, or did you need to speak with Mr. Wassery?
We're good.
We're not on the same page as we were, Mark. Do you want to just proceed or do you want to meet real quick?
Let's meet real quick then. Thanks.
Thank you, Your Honor.
No problem. I'll move you both to a different room because Ms. Penn is in your other room. Or put you both in room 4. Oh, I think that was from that file. On the record in the matter, again, of the people of the city of Lansing versus Stephanie Schmitz. We have Mr. Hannah here. And I had previously gone over with you, Ms. Schmitz, about your rights. The indication that you're providing to the court is that you want to plead guilty, but with an explanation. However, the explanation you provided I don't think would be sufficient factual basis for a guilty plea that you accidentally consumed alcohol or that you didn't know you were drinking alcohol. So if that is still your position, we're going to proceed with the hearing at this time. So, Mr. Kuntz, is that still how your client wants to proceed?
That's right, Your Honor.
Okay, Mr. Boyd, you can proceed with your with your witness.
Your Honor, the city calls probation officer Brendan Hanna.
Okay, Mr. Hanna, can I have you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is true to the best of your knowledge, information, or belief?
Yes, Your Honor.
Thank you. You can proceed, Ms. Boyle.
Thank you, Your Honor. Mr. Hanna, can you advise the court as to how you are currently employed?
I'm employed as a probation officer at the city of Lansing in the 54 District Court.
Okay. And are you familiar with a probation matter relating to Stephanie Schmitz?
Yes, ma'am.
And how is it that you are familiar with that particular matter?
I submitted a probation violation on the date of April 6, 2022.
And what was the nature of the violation?
That she tested positive for alcohol on February 24th, 2022 and March 9th, 2022.
Okay. And how is it that you became aware of that violation? Is there something that Ms. Schmitz did that prompted that?
I just received a number of test results a little late from Adam, and one was from the 24th of February, stating that she had 313 nanograms per milliliter of ETG, which is basically alcohol in her system. And on March 9th of 2022, I received a result that she had 49,450 nanograms per milliliter of ETS, which is another metabolite of alcohol in your system, ethyl sulfate.
And based upon that information provided by Adam, did you reach any conclusions?
I just reached the conclusion that she consumed alcohol, so I violated her accordingly, violated her probation.
Do you have any reason to question the accuracy of the drug results provided by Adam?
I don't.
The city has no further questions at this time, Your Honor.
Okay, thank you. Mr. Kuntz, you can cross-examine.
Thank you, Your Honor. Good afternoon, Mr. Hanna. Can you hear me all right?
I can hear you.
Okay, and can you do me a favor? Can you let me know if you don't understand any of my questions so I can rephrase?
Yes, sir.
All right, thank you. So we have two test results at issue here, is that right?
Yep.
From February 24th and one from March 9th of this year?
Yep.
Okay, and so the February 24th test result came back at about 314 nanograms per milliliter of ETG, is that correct?
Yes, sir.
Okay, and what does ETG stand for?
It's ethyl. I'm not a toxologist. It's ethyl something,
Sure.
but it's a metabolite for alcohol. Breaks.
Glucuronide or something like that?
Yeah.
That's all right. Okay.
And
And
sulfate is ETS is ethyl sulfate.
okay. So positive for ETG, was there any ethyl sulfate present in that test?
No, there wasn't. Zero.
Okay, and so both ETG and ETS are metabolites from ethanol consumption,
Yes.
and ethanol is what we commonly refer to as alcohol. Is that true?
Yes.
The thing that gets you drunk from liquor, beer, wine?
Yes.
Are there other places ethanol can be found?
Yes, it can be found in like things like kombucha tea. Oh, that's all alcohol though. Alcohol, like NyQuil, cough medicines, things like that.
Okay. And so the March 9th test, positive for, it looks like a big number, almost 50,000 nanograms per milliliter of ETS.
Yes.
Was there any ETG present?
No.
All right. So I guess, do you know, I know you're not a toxicologist, but in your training as a probation agent, do you know how alcohol or ethanol metabolizes?
I do not.
Right. Could you explain why the March 9th test would be positive for ETS and negative for ETG?
I cannot.
You explain why the February 24th test will be positive for ETG and negative for ETS?
I cannot.
Do you know what, I guess, do you know, are these levels of ETG and ETS respectively, are they significant?
The ETS was significant. I'd never seen one that high. That's why I was a little alarmed by it. I thought it was weird there was no ETG, but I mean, with that high of a level of ETS, I still had to do something. And then with the ETG, a 313 is a low level nanograms, but usually means like if it's 313, someone may have ingested some cough medicine, something, but still usually cough medicines have a big label that say, like NyQuil will say alcohol 10% right on the front. So
All right.
still warrants a violation.
Sure. And so going back to the March 9th test, so this was a particularly high level of ETS in your experience as a probation agent?
Yes.
No ETG?
Yes. No ETG.
Now, on these, I guess, in your experience as an agent, is this common?
No.
That there would,
not common.
okay. Is there usually both ETG and ETS present?
Usually.
Okay. All right, Agent Hannah, I think that's all I have for you. Thank you.
Thank you. Ms. O'Boyle, did you have any additional questions?
No, I do not, Your Honor. Thank you.
Okay, thank you. Did you have any other witnesses?
No additional witnesses at this time, Your Honor. Thank you.
Okay, Mr. Coons, do you intend to call any witnesses?
No proofs, Your Honor.
Okay, you can make argument, Ms. O'Boyle.
Thank you, Your Honor. I believe that as the probation officer testified, the results were conducted by the Alcohol Drug Administrative Monitoring Company, which is commonly used by the city of Lansing through probation. There's nothing that indicates that the results of these tests, although perhaps not usual of typical results, there's nothing to indicate that they are inaccurate in any way, nor is any evidence been presented that the information contained in those reports is inaccurate. Therefore, it does seem consistent that Ms. Schmitz did in fact violate the terms of her probation by having metabolites of alcohol in her system.
Thank you. Mr. Coons.
Well, Your Honor, I'm asking the court to find Ms. Schmitz not guilty on the allegations here. We're not contesting that I guess we're not contesting the veracity of the results here. We're not saying that the ETS levels were off because we don't have an independent test to say otherwise. And that's for the March 9th test. For the February 24th test, we're not saying that the ETG levels are off. Because we don't have an independent test to say otherwise. But what is remarkable about this is where we have a large amount of ETS present on March 9th, we have no ETG present. And where we have ETG present in nominal amount on February 24th, there's no ETS present. The burden of proof, I mean, it's a preponderance of the evidence. It's not beyond a reasonable doubt. I'm fully aware of that, but it still rests on the city. And what the city has provided are two tests that have results saying that there was on February 24th, one metabolite, and on March 9th, the other metabolite. Neither coexist at the same time. We don't have a satisfactory scientific explanation as to why that could be, or why these tests are consistent with drinking. So I'm asking the court to find Stephanie not guilty. Thank you.
Okay, thank you for the testimony provided by Mr. Hannah, who's supervising Ms. Schmitz during her term of probation. She was placed on a term of probation by this court back on January 24th, 2022, and she was given some conditions of probation. One of those was that she was not to use, purchase, or possess drugs or alcohol unless she had a valid prescription. We have here allegations that she tested positive for alcohol first on February 24th, 2022 with the ETG of 313 nanograms per milliliter, and on March 9th, about 2 weeks later, with an ETS of 49,150 nanograms. The argument of the defense is that because one measure does not contain an ETS and then the other does not contain the ETG, that doesn't provide the court with sufficient evidence that there was use of alcohol. I would disagree to that. I think there's nothing that's been provided to allow the court to believe that these measures were inaccurate and that they would be inaccurate or invalid because they did not include both an ETS and ETG. There's different measures for metabolites. Again, Mr. Hannah is not a toxicologist, but there's also been no evidence that or dispute that there was an accuracy in the testing, other than the fact that because there's no ETS on one and no ETG on another, I don't find that argument to be sufficient to dispute the fact that there was the presence of alcohol or an alcohol metabolite in Ms. Schmidt's system on the dates in question. It also should be reminded that Ms. Schmidt was willing to plead guilty with a explanation that essentially she was not aware or did not voluntarily consume alcohol somehow along the lines, and I'm not sure what that means, but she must have known that she was under the influence of alcohol of some sort if she was willing to plead guilty to the violations, but provide an explanation that she didn't drink it willingly. So the court is satisfied that there's sufficient evidence to sustain the violations. I did not take a plea under those circumstances because if there was maybe one violation, I could probably buy that excuse, maybe with a raised eyebrow. Definitely not going to buy it for 2 days, 2 different violations. One, an extremely high metabolite in her system 2 weeks after the first time. I can't buy that at this point. And then at this very adult age, for anyone to come before the court who's on probation for having a super drunk, essentially was what her blood alcohol was at the time of the underlying incident, to come before the court and want the court to believe that she drinks stuff and she doesn't know what's in it, then we got a bigger issue anyways. So the recommendation here of probation does not seem to address this violation. Mr. Hannah, it does say here that it wants her testing to be increased, but also that she is already in IOP and 12-step, and she claims to have been in hospital. Is that why you removed some of the other violations? Is that what this explanation is for?
Yes, Judge.
Okay, very good. Okay, Mr. Cooch, you can address the court before I sentence her on the violation.
All right, thank you, Your Honor. I guess I'll pick up where the court left off. Stephanie's doing well. I understand the court's findings today, but we need to be mindful that the first one was 3 months ago, and the second one was going on 3 months, about 2.5 months ago, and that's not to excuse them or explain them away, but what I can say is it's given time for Stephanie to both hit rock bottom and start finding her way back up. What's not included in these allegations is the reasoning for the hospitalization. It's something I did contact Mr. Hannah as soon as I found out, which was I think just a couple days after Stephanie went to the hospital. First on March 10th, then she checked herself out, and then checked back in March 12th, was there through March 27th. It was it was because of an overdose, not alcohol, but other substances. And I think that was rock bottom for Stephanie. And what I've seen since then is hard work and acknowledgement of just how hard of a journey this is going to be and how much of a problem it is. She is going to AA, I think 5 to 7 days a week, you said, and in some weeks every single day. She has completed some, I think some of the courses she was ordered to, all of them, I'm being told. She's enrolled herself back in school to be a vet tech, is that right?
Yeah.
And sounds like that's going really well. The third final exam, I think it's kind of like a work at your own pace type of course. Third exam isn't due yet, and she's already working on the fourth. So, Your Honor, I'm just asking that probation continue. Relapse is part of recovery, and this recovery is going to be a lifelong journey for her. I just ask that the court give her another chance and continue to provide her the resources to succeed on that journey. Thank you.
Thank you. The request from probation is to have Ms. Schmitz increase the frequency of her testing to 4 times per month. I'm going to grant that request. I'm also going to extend her probation an additional 90 days. I recognize that she's getting on track, and I have not seen any violations since the one in April, which I would dispute is 3 months away from now. But it was over a month, almost 2 months away. And so that's good that you're getting on track, but also recovery includes acknowledging when you are having an issue and coming before the court and indicating that you accidentally drank alcohol and had a blood alcohol, or I'm sorry, had an ETS of 4,900 450 nanograms is overwhelming. And so if Ms. Schmitz, you do have a practice of being around people where in circumstances where you get a beverage and you don't know what's in it, for your own safety, ma'am, not even just for your recovery, you need to make a better choice as it relates to that. You should never be consuming something if you don't know what's in it. There could be something harmful or detrimental to your life in that, if that's the position that you're taking. So with that being stated, I'm going to congratulate you for continuing in your treatment. It looks like you're already continuing in your 12 step. I'm going to grant the request to increase the frequency of your testing, at least for the next 90 days, 4 times per month. You'll be testing. And then I'm extending your probation another 90 days. I think I originally only put you on a probationary term of 9 months. I think you would benefit from some additional time in order to stabilize and ensure your recovery. Do you have any questions for the court at this time?
No, Your Honor.
Any additional matters for the record, counsel?
No, Your Honor.
Nothing for the city.
Not from us. Thank you, Your Honor.
Thank you. You're all set. Mr. Keithley, which matter are you here for?
I'm here regarding Mr. Davis, Your Honor.
Oh, there we go. I was gonna say, I don't see it. Nobody else did it. So I'll just do it. Mr. Davis, can you hear us?
Yes, Your Honor.
Okay, thank you. We're on the record in the matter or matters of the people of the city of Lansing versus Darren Jaquez Davis, file numbers 20-03676 and 3677. Council appearance, please.
Good afternoon, Your Honor. Amanda O'Boyle appearing on behalf of the city of Lansing.
Good afternoon, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Mr. Davis, who is present via Zoom.
Thank you. And today was the dates of the pre-trials on both matters. How do we want to proceed on these?
Thank you, Your Honor. An offer was extended to Mr. Davis today that would be essentially to admit to a breach of the peace civil infraction in the file ending in 7-7, and in exchange, the file ending in 7-6 would be dismissed. My understanding is Mr. Davis would like to accept that offer.
Mr. Davis, is that correct?
That is correct, Your Honor.
Okay, I'll note here in the file, you're in the Department of Corrections. For how long?
That's correct, Your Honor. To 23 of October.
October 23rd of this year, or were you saying October 2023?
2023. Sorry about that.
Oh, okay, sounds good. Okay, I'll note here that you're accepting responsibility to the breach of the peace civil infraction. I'm gonna waive fines and close the file. You're all set, sir.
Thank you. Have a nice day, Your Honor.
Same to you.
Have a good afternoon, Your Honor.
Same to you. Ms. O'Boyle, do I have anything else for you?
No, I don't believe so. Thank you, Your Honor.
All right, thank you. Ms. Courtroom, are you all ready to go on this pen?
We are, Your Honor.
We're on the record in the matter of the Autumn Ridge Apartment versus Stephanie Penn, file number 20-02613 LT. Can I have your appearances, please?
May it please the court, Mark Wasbury on behalf of plaintiff.
Thank you, Your Honor. Christina Corcoran appearing on behalf of Ms. Penn, who is present in the Zoom courtroom.
Today was a date that was set for a motion to show cause. You have met privately with each other, and I'm not sure if you want to give me an update on what you are ready to do or
Yes, Your Honor, I can do so.
move forward with the motion. Okay.
Thank you, Your Honor. As you indicated, we are here on defendant's motion to show cause. It is defendant's position that plaintiff has failed to complete the agreed upon repairs, and therefore they are in contempt of the order. And Ms. Penn is here to testify if Your Honor would like proofs to be placed on the record. We ask that you find plaintiff in contempt. We ask that you that you sanction them as the court seems appropriate, that you order them to complete all of the agreed upon repairs within 28 days, and that Your Honor finds that her rent is paid through June of 2022.
May I respond, Judge?
Yes, you can respond.
Okay, Judge, we agree that the rent should be waived through June of 2022, because the roof has not been fixed. However, my client has obtained a vendor for that. My client, the property manager, is Molly Lamb, and she's also on this call today. However, as soon as we received the show cause, I asked my client to look at the records, and my client found a work order from the summer of last year of 2021. I'm sorry, 2021, where these issues were addressed. The roof was not addressed. These are based on the books and records of the file. However, Ms. Lamb just came into this position in the middle of last month. So when we received the show cause, all this was new to Ms. Lamb. There was a different property manager. When we met privately with Ms. Corcoran, I said, well, this is very simple. These are all very straightforward things. It's a water leak in the dishwasher. Either it's there or it's not. It's a thermostat. Either it's new or it's not. Kitchen tiles missing. Either they're missing or they're not. I suggested we walk through and everybody will have a chance to take photos if they disagree. Ms. Lamb has no personal knowledge, but certainly we agree with Ms. Corcoran that these issues should be addressed in the next 28 days. We'd like to get in there as soon as possible to see what, if anything, other than the roof is still outstanding. I certainly don't think we should be punished when I also, as the attorney, I was unaware of this conditional dismissal entered in December, as I am brand new to the property also. And so that the roof is being attended to the extent that our work order from the summer of last year is wrong. We certainly want to know it and take care of those issues, Judge. So I don't think a fine at this point would be the right thing to do, since we're new to the situation and we like to go in there and place our own eyes on it. If the court wants to hold that issue in abeyance, maybe that's the right thing to do.
Anything else, Ms. Corcoran?
Thank you, Your Honor. I understand Mr. Westbury's position. He is new to representing Autumn Ridge. I am not new to representing Ms. Penn. She contacted our office in January of 2020 regarding these issues. Autumn Ridge has not been in compliance with the city of Lansing since, I believe, 2018. They're still not a registered rental. As far as punishing them, Autumn Ridge is one of those properties where I am constantly feeling like I'm failing my clients, because they are continuously bringing tenants to court and asking for money, but they are continuously failing to keep their properties fit for the use intended. Ms. Penn has only wanted to live in a property that is fit for the use and be able to pay her rent. And I will tell you, and she entered into this agreement fully aware of all of her circumstances involuntarily, but she was extremely stressed out about the fact that she was concerned plaintiff would not make the repairs. And here we are 5 months later, and she's indicating that the plaintiff has not made the repairs. For those reasons, I do think a monetary sanction is appropriate, but I will defer to Your Honor.
Thank you. And as of right now, the roof, we know, there's clearly has not been addressed. Is that accurate?
That's right. My client is dealing with the vendor, right, has found a vendor and has done the check request to corporate to get that taken care of.
Your Honor, may I, and I don't want to belabor the point, but it's not just a matter of the roof not being repaired. Because the roof has not been repaired or hasn't been in such disrepair for so long, there's continuous damage coming through Miss Penn's roof, or I'm sorry, ceiling. She's had to regularly send me videos where it's just water dripping into her living room.
Your Honor, the prior order, the CD entered in December, addresses our punishment if the roof is not timely repaired. We waive rent through June. So again, and we've agreed, rent should be waived through June. I would ask that.
The agreement doesn't absolve you from a contempt of court order.
I agree, Judge, and that's why I asked that it be held in abeyance, because the property manager we have here today has just arrived. I don't think I think it's only fair. I don't think it's really fair to refer to other apartments as Ms. Corcoran was referring to, because we're talking about one apartment today. And so Your Honor still has contempt powers if we come back in a month after addressing these issues.
Okay, so I had stopped at the roof leaking. I recognize and I appreciate clarifying that the leaking roof is not just an issue of a leaking roof, but it's causing continuous damage in Ms. Penn's property. I just wanted to go through this list as dated December 1st, 2021, because I want to know how much of this list has been addressed or has nothing been addressed.
Thank you, Your Honor.
Is the dishwasher not addressed?
Would you like, Your Honor, would you like me to answer that question or Ms. Penn?
Ms. Penn? Is your dishwasher still leaking?
Yes, ma'am.
Okay, what about the kitchen tile backsplash? Is it still falling off?
Yes, ma'am.
What about the vermin in the walls of the apartment?
They still here. They're getting worse. They still here on my roof and the walls. You hear them when you go to sleep. You hear them in the morning before the sun come out. Yes, ma'am. All that's still relevant. All that's still happening.
Okay, do you still have black sludge coming up through your basement?
Yes, ma'am. Yes, ma'am.
What about corroded water heater that is incapable of keeping the water hot?
Yes, ma'am. That's still happening. Yes, ma'am. That's still happening.
Okay. Do you still have mold-like black substance covering the walls in the basement?
Yes, the maintenance came in and sprayed my walls with white paint a couple of months ago, and the black stuff is coming through the paint.
Basement thermostat heater vent blows my heat upstairs from the basement.
Yes, I have a thermostat in my living room, and when the maintenance came initially, they said the furnace is in the basement, and they asked what was the problem, and I said my townhouse is cold. When I put it on 70, the thermostat is on 50. I have to put it on 90 for it to get to 70, which increases my utility bill.
Okay, and that was going to address the next issue before the leaking roof. So based on this, in the last 5 months, there's been no efforts to repair any of the issues that was agreed upon. And so I don't believe that Mr. Rosary, your client, operated in good faith. I recognize that you're new to this. I recognize that there was another attorney on this. And maybe now that you are providing legal counsel to Autumn Ridge, they'll do better, but they will be held in contempt today. And there will be a fine in the amount of $1,500. You're gonna allow people to live in under these conditions through the entire winter. These were the conditions in which they had a tenant living. And I would imagine there must not be another option for her to go, because I don't see how these conditions are livable. And I know myself, I know you, Mr. Wassery, wouldn't live under these conditions. I know Ms. Corcoran, and I'm pretty sure your client who's represented today wouldn't live under these conditions. So to ask to hold any further citation in abeyance for 28 days so that your client can bring it up to date. They still are going to be required to bring it up to date because they should have done that before. I'm going to set this for another hearing in 28 days. And I expect that there will be a good report at that point. I will grant the request for the rents to be waived through June 2022. Fine in the amount of $1,500 for contempt of the court's order. And then what was your other request, Ms. Corcoran?
I believe Your Honor has covered all of the requests.
Okay, thank you. I'll give you another date, 30 days out.
Thank you, Your Honor. And then I will prepare an order under the 7-day rule.
Could you just send it over to me, Ms. Corcoran? If it satisfies what the judge says, we'll just get it entered.
Thank you.
June 23rd at 8:30. Does that work for, well, I don't know if it works for Ms. Corcoran, but.
Someone from my office will be here, Your Honor. Ms. Penn is aware
I
that
issue an
someone.
order to make you come back regardless.
Well, I don't want to ever be in contempt, Your Honor, but unfortunately, I will not be here.
Okay, I do see someone from your office here, I believe.
I see that person as well. Unfortunately, I'm not familiar with that person.
Your Honor, I'm just a student observing. Thank you.
Okay, sounds good. Thank you.
And Your Honor, I'm sorry. What time was it on the 23rd?
The 23rd at 8:30 in the morning.
Thank you, Your Honor. That will be all for defendant.
Thank you.
Thank you,
And
Judge.
you will thank you. You're providing an order to Ms. Wasbury today as opposed to.
That is correct, Your Honor. I will set it. I will draft it as a stipulated order.
Thank you very much.
Thank you, Your Honor.
Have a good one.
You too.
Okay, Mr. Smith. I don't see Harold present with us. So you.
Court file should reflect personal service, March 28th.
Okay, you can submit your show cause.
Okay, we'll get that filed and entered. Thank you for your help, Your Honor.
Thank you.